committees that are in the Parliament is looked at by a number of committees who then give their views and all come together to the lead committee, which is the Libe committee, the Justice Committee. And the ones that have tended to look at it, I mean, one of them is the Industry Committee and so on. And I would hope that when it gets to the Libe Committee itself, you'll get a slightly more balanced view. But the Parliament comes to a view, and that's one part of the negotiations. At the same time, but if you like, much less publicly, you've got the Council, where the Member States' governments are represented, also, you know, pulling it apart and coming through their amendments. And it's probably perhaps some more in the Council where some of the pulling apart of the Commission's proposals is really going on. But the idea is at the end of the day, the Council adopts a position, the Parliament adopts a position which they're expecting sort of around about May, June time. And then they come together and try and come to a compromise, with the Commission then involved in, you know, developing new wordings and new forms. So that's where it is. And we are not part of that. We give our view to the government, the Ministry of Justice there. We give our views to MEPs, particularly UK MEPs. And through the committee we sit on with other data protection authorities, known as the Article 29 Working Party, we do publish opinions and views which are no doubt influential, and there's no doubt that the Commission as well take note of those. Just worth remembering, there are actually two proposals on the table. There's the regulation which has been talked about, which is the one which essentially replaces the existing directive on which our UK Data Protection Act is based. There's also a directive proposed addressing data protection in the law enforcement and justice area. And although nearly all the attention is on the regulation, in many ways you may not agree, but our perception, I think, sort of the law enforcement and justice area is probably the area which has the biggest threat to individuals' privacy, because so much of what goes on is unknown and unseen. So that is a particularly important instrument, but it's also one which engages a lot of political interest from the member states. It's basically Brussels interfering in policing domestically, which creates a lot of resistance, not just from the UK. And I don't know whether your fellow panelists agree, but it seems to be that that directive is sort of being sidelined. It may never come about. All the attention is on this regulation. There's a lot of pressure to get it through, driven by the Commissioner, Viviane Reding, and all the timescale is driven by 2014, when her term of office comes to an end and we have European elections. So if it's not through by then, it doesn't quite start again at the beginning, but it goes back a long way. So there's a huge drive to get this through. But it's not just engaging wide areas of political interest, it's actually a really difficult job. We're talking about personal data and the extension of personal data. That's right, and our view is that the scope of the proposal, what's in there, is no different or very little different from the current directive, which does cover, at least in many circumstances, things like IP addresses. But there is a reaction against that and saying, this should become narrower. We are resistant to it. But people are talking now about introducing a definition of pseudonymous data into the proposals and that if you have pseudonymous data with partial identity, you'll be relieved from some of the obligations that go with that. An interesting concept, but actually very difficult to draft in a sensible, proportionate, and a way which doesn't essentially cut holes in the legal protection for individuals. And there is, there's some lessons from Brussels that when you start to deal with these difficult questions under political pressure, times against you, trying to sort something out, you actually come out with something which doesn't work very well in practice. So there's a risk there. I won't go through all the points. I will just pick up on consent. I mean, the text in the regulation is explicit consent. So when consent is relied on, then it should be absolutely clear that someone has agreed. It's not these days signing the box, but clicking or whatever, that there's no doubt that someone has agreed. Very much something that we support and wouldn't want that to be watered down. And again, some of these amendments are about trying to water down that arrangement. Just updating people's access rights. It's still the case that in this day and age, even if I do business with you online, and I want access to the data I hold, you can require me to sort of write to you by snail mail making my request, and you have 40 days to respond. I mean, just updating that so all that can work electronically and there's not any charge anymore. It is very important. I agree with you about right to be forgotten. This is a political, well, even Viviane Reding herself said this is more of a political slogan than a reality, and it's about selling the idea. There are some important things there, and the bit of it which we think is particularly important, we want to retain, is the bit that's called right to object. We have it at the moment. I mean, I can go to any organisation and say, I object to you processing my personal data. And they have to stop, but only if I produce compelling, legitimate grounds. So I have to make the compelling case as to why they should stop. And essentially the proposals reverse the balance of proof. I can go to an organisation in future and say, stop processing my data. And they have to produce the compelling, legitimate grounds for continuing to process. And of course, very often there'll be those. I can't go and demand, if I owe someone money that they delete my account or whatever. They will have, but that change of balance changes the power of it in the relationship. So there's a huge amount that's good in the proposals. We very much welcome them. There is, in our view, too much bureaucracy in there for business. So there's a huge amount of form filling needed, which I don't think goes to the fundamental rights that we're interested in protecting. And too much bureaucracy leads to data protection being seen as red tape, burdens on business, and that's not actually helpful in delivering effective rights at the end of the day. So the rights need to be preserved, but some of the sort of bureaucratic element of it, and it is a bit over-prescriptive, over-detailed to achieve this harmonisation. Some of that just needs scaling back.